Ladies and gentlemen, I thank you all for attending tonight's conversation. I'm probably new to all of you because I'm in some 14 days in the new job, so I'm the new head of school. But it's not my task today to talk about that office or myself, but to introduce two of our conversationists, if we call them that, but essentially two personalities from our legal profession who are here to discuss with us in a kind of open and candid way their views on law, constitutionalism, and the direction in which the legal system may or may not be going. I don't mean that to be the questions already for them to answer, but it's my particular important task today to introduce the two guests, chaired by Professor Mohango in the middle. I will begin with Justice Cameron, who is a Justice of the Constitutional Court, long-standing friend. He asked me not to read out the 3-page CV in front of me, but a long-standing friend of Wits University, especially the law school. I reminded him today that we met in around 1988 at the Gordons Bay workshop on the constitution that was drafted by the Nationalist Party on group and human rights. And I can understand why he can't recognize me, because I've grown a great deal more grey since then. But Justice Cameron's own CV has been linked directly, not just to his legal work, but also for his advocacy for HIV/AIDS victims, people who live with HIV/AIDS. And he's known in the media, both nationally and internationally, as a very strong advocate for those persons living with HIV/AIDS. I think that'll be a short enough introduction of him, because otherwise we might have an argument later. The other conversationist today is Themba Langa, who is also a Wits graduate and who has had an experience essentially in the commercial world and with linkages to the European Economic Trade and Commerce Commission. He has worked and established the firm Langa Attorneys, and his practice is essentially the area of commercial and corporate law, with a particular focus on funding and structuring of transactions to pursue empowerment opportunities. Welcome to both our speakers, and over to the chair.
Thank you very much, Professor Judicial, for the introduction. Can you hear me well back there? Okay, thank you. But first, I want to welcome my guest, Justice Cameron and Mr. Langa. Thank you very much for being here. I really appreciate that you're doing this. And also welcome to the audience for being here. And I was told, I was asked to start my conversation today with Mr. Langa, but I think that I'm going to have to disappoint Justice Cameron and direct my first question to you. Recently, Justice, you made a speech which was later published in the Sunday Times. And I think in your speech you were essentially talking about the history, our constitutional history for the last 20 years. And but you made a very powerful statement which I want to ask. And you said that in your view, constitutionalism remains the best path that we have in South Africa. I want to just, if you could just tell us, how would you characterize the role of the court in that path that you so very well spoke about?
Well, thank you very much, Professor Mohango, and Mr. Jaichand, I want to congratulate you on your appointment. If I may evade the question for a moment, as the new head of school. And I'd also like to say how pleased I am to be here at the Wits Law School this evening, and particularly with Mr. Langa. Mr. Langa offered me a bribe this evening. He said that if he answered all the difficult questions, would I promise him a judicial appointment? So I said yes. So I suggested that he should take the question first, but Professor Langa broke our deal. Professor Langa, that's a very good question, and we've got to go back to power. And a legal system is a form of political power. It's a form of political power triggered by lawyers and litigants and people and exercised by judges, but it is a form of political power. And in South Africa, for very particular reasons relating to the nature of the apartheid legal system, the nature of our transition, the geopolitical factors that took place at the time of our transition, everyone agreed that the basis of our transition as a country, as a nation, as a people, should be the law. And the law embodied in a strong constitution, constitutional supremacy, a constitution that was above Parliament, above the executive, above all people who wield power, including corporations and private persons, and above the judiciary. And after 20 years, I think we can look back with some grief, with some sadness, but also with a measure of sober realism about what the Constitution has done in the last 20 years. It hasn't been an unparalleled success. It hasn't achieved what those of us meeting 25 years ago about various constitutional plans at the time hoped that it would achieve. We're a sadder, more realistic nation, a sadder, more realistic profession of lawyers, a sadder, more realistic cadre of judges. But I think the Constitution, despite all of that, has proven itself in enough areas for us to say that it has done part of its job, and it's our best hope for it to do the rest of its job. That's our job. It's my job as a judge. It's Mr. Langa's job as a commercial lawyer and as a human rights activist. It's your job and Professor Jaichand's job as law professors, and it's the job of all the law students here and all our colleagues here, which is to make the Constitution work, which is to make it an effective form of the exercise of political power, which is for social justice. That's the key feature of our Constitution, is that it employs legal and political power in order to achieve social justice.
Well, thank you for that. I think the last point that you make about social justice, I mean, I'm reminded of what the late Justice Langa said in his famous article titled The Transformative Constitution, where he basically says that all courts commentators agree that our Constitution is a transformative document and to achieve the social justice as you mentioned. And I think that leads me to you, Ms. Ella. If we all agree, I think this is one of the very few moments where academics and judges agree that our Constitution is a transformative document. But how would you, as a practitioner, characterize, or how would you say that the Constitution fares in trying to achieve all those, I think, the values that you find in our preamble, that we must put ourselves to transform the society? Has it fared well in your view?
Okay, before I respond, I must thank you for the invite. I must thank you. And I also would like to acknowledge, the courtesy afforded by Justice Cameron, to have a discussion with me sitting across. I think it's quite courteous. And I just want also to preface my input by saying that in everything that I'm saying with humility and with utmost respect. Because I'm scathing views about the Constitutional Court. So I hope
Sounds good.
Yeah, look, I think personally, it is true that the Constitutional Court is done very well. It is true that the Judiciary, as a cornerstone of our democracy, has to be cherished and has to be upheld at all times. And I cannot overemphasize what Justice Cameron just said. And to that extent, I think we're in agreement. Where I think I've got a bit of a difficulty, it is where the Constitutional Court, in particular, not the Judicial, I just want to separate the two. I'll come to the Judicial. I've got a difficulty with the Constitutional Court, that behaves as if the people, particularly on issues that concern the executive and the legislature. You know? I may not succeed to traverse issues to the extent to which I would like to, but for the purpose of the discussion, as I said, there is a good of that has been done by the Constitutional Court. But I am concerned that there is a tilt towards undermining the government.
Too populist.
Exactly, you know, but populist to one end of town, you know. You see, you know, Judge, I've got a difficulty where the Constitutional Court, when it comes to some cases such as Mirafo, you know, the Ito case, you know, they seem to be. Okay, let me first, before I proceed, let me just to face this. You know, the Constitutional Court confuses us at times in practice, in that the standard processes that we all grew up to follow. It looks like with the Constitutional Court at times, and the Supreme Court of Appeal has joined you guys recently. It is only there to serve the purpose of the judges. And I listened to your opening statement. You said the Constitution as a law is above all of us, including judges. But at times, that's not the impression that you get in practice, because you guys seem to be vacillating, to be too flexible, particularly on issues that have to do with the executive. And that is compromising us, in that judge is not something desirable as a lawyer to be faced with the difficulty that what is the Constitutional Court doing in this regard. The Constitutional Court appears to be temperamental at times, appears to be populist at times, you know, but we don't get that line that gives us certainty, and even we don't need certainty at all times, but even where there's a departure, but there must be established steps and norms, as it has always been the case. Let me take a simple case of the Sarfo case. In the Sarfo case, we get told by the Constitutional Court that in where the executive is seized with the duty to perform a function, when the court approaches such a situation, the court will be seized with whether the executive concerned applies his or her mind to the matter. And that is a law. And then you go on, for example, you get to the case of the Democratic Alliance versus the President on the Simelane case. When it comes to that case, Judge, the Constitutional Court, and I'm saying this with utmost respect, does not even get into the inquiry as to whether did the President exercise his mind on the matter. What it does, it creates a new set of prescription to say, no, this is what he has done. But he should have done this. But that's not the law, Judge. That's not the law. The law is whether has the President applied his mind on the matters before him. And then we have to look into what were the matters before him. And we look into those matters before him. And then in this case, we get told in the law report that, for example, the President looked into the issue of the Jinwala Commission. For all I care, the outcome of the Jinwala Commission is an opinion. It's not a court order. It's an opinion that is not even higher than that of a senior attorney. It's an opinion that is not even higher than that of a senior counsel, you know. And it's an opinion that is not even higher than that of a judge in a normal court, where the judge will make an adverse view about the conduct of a particular witness. However, in the Constitutional Court, the judges have raised an opinion to say why did the President fail to consider an opinion, which is just an opinion. For us, it's disappointing. And I think for me, while I agree that the Constitutional Court has done a lot of great things and it should be cherished and upheld and protected, but I'm concerned with the willy-nilly nature, particularly which appears to be temperamental when faced with particular cases. That's my only concern.
Thank you for that. You've led me to think of a question which I was going to ask, but I'll let Justice Cameron just maybe respond before I come in.
Thank you, Professor Langa. First, I want to say that when a skilled lawyer says he's saying something with utmost respect, you know you're going to get a clap. So I want to thank you for the clap. Secondly, I think the charge that you've made is an important one, which is that the court is too populist. And I'd like you to clarify it later. I don't want to challenge you. I don't want to cross-examine you right now. I want to say one thing about the Simonani decision very briefly. Former Speaker of Parliament Janwala was appointed by President Mbeki under a constitutional provision to inquire into whether the National Director of Public Prosecutions should be dismissed or not. So it was a constitutional commission chaired over by a lawyer, a very experienced constitutional lawyer. And in the course of it, certain evidence emerged in open proceedings that reflected on the truthfulness and probity of the witness concerned, who was Mr. Simonani. And in the case before us, it was indicated that the President hadn't considered that the evidence that emerged in that case, not based on a whimsical opinion of the chair, former Speaker of Parliament, Freddie Janwala, but on the transcript that was before us and which is quoted extensively. But I don't want to get into a defensive point there, Mr. Langa. I think our decision was an important one, and I will defend it on its own merits, which is that when the President exercises a very important power, which is to appoint the head of a Chapter 9 institution which is meant to preserve constitutionalism and democracy, the head of the National Prosecuting Authority, we're not going to say who he must choose. We're not even going to say whether his choice is right or wrong. But we are going to say that in applying the statutory prescripts, that the person has to be a person of a sufficient character to be appointed. He must go about it in the right way. And when he ignores a public commission which shows disturbing evidence of lack of truthfulness, falsity, and lack of probity, then he hasn't gone about it the right way. Now, I think that decision is right, and I appreciate, in fact, it's very rare that we get such candid criticism, and you say you want to thank me for coming here. I want to thank you for coming here in front of a critical and audience that's hungry for information, for being so candid about that. And I'm very happy to pursue the debate on that basis further. I really appreciate it. Doesn't mean I'm not going to give you claps back.
Having introduced this, the outer case, or the e-talk case as it's popularly known, Justice Cameron, in the speech that I referred to earlier, you also made some comments about that judgment. And this is what you said. You said that courts are cautious when it comes to purely policy questions, but that courts hold government strictly to account when it comes to social delivery programs. Now, I think for the sake of what Mr. Langa said about, lawyers always want certainty, and I think we all want certainty. But if you were to articulate a principle that emerged from that e-talk case as to how courts will in the future deal with purely policy questions, some people call them political decisions, essentially. What would be that principle that we can then use in the future to say, this is how the courts will deal with questions, political questions or policy decisions that govern the executive state?
Well, look at what was at issue in e-talk. And I take Mr. Langa's point, which is that, in a sense, he's saying our court is too activist, that it meddles where it shouldn't be meddling, if I understand you correctly. And that it's doing so at the instance of agencies which shouldn't be in the courts. But in e-talk, what was at issue was whether government should be stopped from implementing a system which was still going to be reviewed. And the review is now taking place, it's making its way through the courts. On various Paja grounds, the review. But the court, in advance of that review, said stop. Because the evidence before it showed that the applicants, Mr. Wayne Diebenach and others, said this is irrational. It's not the best way to collect revenue to cover the 20 billion rand debt for the upgrade of our province, the Gauteng province's roads. We said, well, it may not be the best way, but that's a matter for government. And when you exercise your power as a High Court judge to stop government doing something pending a proper judicial challenge to the rationality and the evidence before it, you've got to be very careful. And that's the message we sent out. You ask for a principle, I prefer to substitute a message, which is be very careful when it's about the best method to go about, especially to recover revenue. There was a 20 billion rand road debt. How should government go about it? Should it increase the fuel levy? Should it increase general taxation? Should it make a user pay principle for the Gauteng road users? It chose the latter, not for us to decide.
I like what you said. I will give you a moment. The way I read the ETO, and I should put in this is where my line of thought comes in, is that the court basically said that the decision to implement the ETO was a policy decision, which falls at the heartland of the executive branch of government, and that for separation of powers reasons, we are not going to interfere. And the case went away. Now, a few weeks ago, COSATU's provincial secretary, Mr. Dumisani Takiri, was asked at a radio interview and saying, are you part of the review that has gone to the Supreme Court of Appeal? That judgment as COSATU, because you are also against the ETO. And his response was that we are not part of that process, because to us the ETO matter is not a legal matter, it's a political matter. That was his response. Now, what I wanted to ask you, and feel free to also speak on some thoughts you have, but do you think that the courts, in some cases, some questions that come before the courts, they don't have jurisdiction to hear those matters because of the political nature of the matters that come before them?
Look, I don't think the court should be barred from hearing any other matter, even those that are of critical nature. But safe to say that, however, there are instances where you find that traditionally the courts have deferred to other institutions, such as Parliament and the executive and so forth. You know? But I wouldn't agree with. I wouldn't agree that there should be matters which the courts should not be able to pronounce on. Particularly on activities, on government activities. That is a government activity. You know, the courts are fully entitled. However, you know, you should, however, distinguish that from maybe from the long cherished traditional separation of powers, the difference between institutions and so forth. But personally, on the issue of ETO, I think the Constitutional Court has pronounced on the issue, and I'm very disappointed at COSATU for peddling the issue. You know, and it's not a good conduct for a corporate, even if it's a political citizen of COSATU, when the issue has been settled in court, to continue to peddle. Those such tendencies, they create hardship to judges in the courts, because if a COSATU behaves in a manner that demonstrates that, you know, if a judgment is not in their favor, then it's not binding on them, or they're not going to respect it. It creates difficulty for the men in the street. It creates difficulty at the magistrate courts, that escalates to the High Court, and so forth and so forth. And it's even worse when you are in a country where the small claims court are not as active as they used to. And I'm aware that, the Minister of Justice just brought back the initiative, but it creates a great deal of difficulty when the COSATU is not seen to be respecting the outcome of the Constitutional Court in the matter. They don't have to agree with it. And you talk to judges in the labor court, they'll tell you the same hardships, that disobedience or failure to be able to accept the rule of law, the decision, is a problem. So I don't agree with that.
Thank you for that. So Professor Kacharia, who is not here today, If he was here, he would have asked you this question. When you mentioned the question of deference from a separation of powers point of view, you said that where the courts must still hear the matter, but they must, depending on the separation of powers, they must defer if it's if a matter really is at the heart of executive or legislative branch. But what would be the jurisprudential basis for the court's deference? Because there's a lot of writings and questions around what is beyond deference. When you say deference, is it a constitutional imperative, or because as lawyers we always want some jurisprudential basis so that in the future you can be able to advise your clients and say, oh, this is likely to be the outcome in this particular matter.
Look, in some instances there is authority. Let's take the case of of the Democratic Alliance, the motion of no confidence, where they've gone to the Cape High Court, they got loan, then they're now before the Constitutional Court. The issue at hand, and I'm saying this is out of correction, I don't have the advantage of having read the papers like Judge Cameron, but the issue at hand is simple as this, that Parliament has a situation, there is a deadlock caused, or rather that arose from the motion raised by the DA on President Zuma. And from the papers, it appears that the deadlock has to be attended to by the Speaker. Now, in South Africa, even throughout the Westminster system, Parliament enjoys a certain, not sovereignty, because that would take the discussion the other way, is allowed or recognized that anything that happens in Parliament ends in Parliament, except where there's an act of corruption in Parliament, except where a member of Parliament stands outside and allegedly makes defamatory statements. Otherwise, we all recognize that whatever happens in Parliament, Parliament must deal with it. So Parliament, they've got committees. They've got the Ethics Committee, Standing Committee on that and that, they've got all these type of things. So it will appear that in this instance, the DA took the matter outside of the court, outside Parliament into the court, and just Dennis Davis in Cape Town pronounced on the matter. He said, look, we don't want to be involved, we don't want the court to be involved in factional politics. Let Parliament deal with their own issues. That's one essence of deference that we was talking about. And then also the Constitution does also recognize the first of separation of powers. Remember that the Constitutional Court is not the supreme custodian of the Constitution. It's the, alone. Parliament is as well. So it's the Parliament and the Constitutional Court. Anyway, and then you then get into a situation that when the matter gets to the Constitutional Court, with respect, does not seem to observe that type of deference that the Cape High Court accorded to Parliament. What the Constitutional Court then does, it says to them, it gives Parliament two options. You either go and attend to the gap that is there, because the rule that the DA complained about is the rule that says that it was almost like the Speaker did. The Speaker said that he does not have the power to break a deadlock on political issues. He has the power to break deadlocks on policy issues. And the Constitutional Court said, no, go and amend your own rules and fill the gap. And then said, and you come back. And that is, if now, after Parliament has done that, Parliament has come back to the Constitutional Court. The Constitutional Court, I suppose, and I'm saying this out of correction, I suppose they're going to express their view, because they did not dispose of the matter. They actually gave them two options. Said, is either you go and fill the gap, or you allow us to pass a ruling and leave a lacuna, And I think in that instance, the Constitutional Court is again interfering. I think the decision of the Cape High Court was correct in my view. They deferred to Parliament, but in the case of the Constitutional Court, they did not defer to Parliament. They still want to pronounce on the legality of whatever amendment they're going to do on the rule, and I think it's unfortunate. Remember that, and I read an article written by Just Come Up. He made the point some time ago that in an instance where there is a gap in the law, it's not for the judges to fill the gap. It's not for the judges to fill the gap. Because he said persuasively, even other things written by Judge Murphy, maybe today may change it, that in such instances, the judges do not need to legislate. They need to defer again to the legislature. You fill up the gap and so forth. But in this regard, they did not. And for me, I think it was a bit unfortunate that the Constitutional Court opted to be involved in the administration. And my point is this one, Judge, that we should make it, for me, I make a distinction between the act of the Speaker to intervene and the activity of a deadlock. Those two are different. But the Constitutional Court is coming into the administration of Parliament. They are saying to the Speaker, you must administer your House, but you cannot administer at this level. There's a gap. Go through the gap and come back to us. I think that's not right. The Constitutional Court should have said to Parliament, there is a gap here that will look nice, but we defer to your Constitution to attend. And I think you've done that on several occasions, as a Constitutional Court. But in this regard, I don't understand why the Constitutional Court left the matter and said, go in and attend to it and come back to us again. So for me, deference for me, I think that's a typical case for me that I would rely on.
Okay.
Which is much more recent.
Thank you. Just it's coming. I want to move on to something else, but I would allow you to respond to some of what.
Mr. Langa is asking for a clap. Mr. Langa, I want to clap you.
Sure.
The first clap is that we've got a constitution which is supreme, and it is just so that the meaning of the constitution has to be entrusted to a body of people who can say, because the Constitution is itself pronouncing. It says that you may bring a motion of no confidence in the President or in the majority party in Parliament, but it doesn't say when or where or how. It says Parliament may make rules to determine its own procedures, but it doesn't specify when or where or how. But the point is that we have to have judges, and you cannot say that Parliament is an equal guardian of the Constitution, because by saying that, Mr. Langa, you imply that we must give Parliament deference to determine its own constitutional powers and limits. That's the implication. You can counter-clap just now. I'm first clapping. So, if I've misunderstood you, clarify by all means, but I don't think we can avoid the system of courts. Now, Parliament has a lot of say in who gets appointed as a judge. Many people say too much say. There's legislation before Parliament to restrict the role of politicians. But Parliament gets a chance to appoint 10 people out of 23 to the JSC, and the President gets a chance to appoint another 5 out of 23 to the Judicial Service Commission that appoints us. The President gets an extra chance when he appoints the 11 judges of the Constitutional Court, the CJ, the Deputy CJ, and the other 9 judges. So there are very strong checks and balances as to how we, who exercise this power, eventually get to do it. But the guardians of the Constitution are ultimately the judges who've got to say what it means. Now, on the Speaker case, I didn't sit in the case, but my colleagues have considered it, and eventually they will give a judgment. But I understood Judge Davis, and that's a public case. He was saying, when he said he's got to defer, the DA came to him in December and said, force the Speaker to give us a date now, the date that we want, before Parliament adjourns, and he said, we're not going to do that. That's not the court's role. The Speaker then said, I admit that Parliament hasn't got sufficient rules stipulating when and where an opposition party may bring a motion of no confidence, which is its entitlement under the Constitution. And that's what's happened since then. So the question before the court, part of the question, is whether the speaker should be told to go and formulate those rules. That's part of the question, but I didn't sit in the case, so you and I can share our blissful ignorance about its details. But I do think the underlying question, the background to Mr. Langa's disquiet about the Constitutional Court, I think, and again you can correct me if I'm wrong, it's a disquiet about the curbs on power, on parliamentary power, on someone saying to Parliament that the best instance that the Constitutional Court gave of curbing, of telling Parliament how to exercise its power was a populist measure. The Constitution says that Parliament must facilitate popular participation in its processes, and Parliament didn't do so. It passed the abortion legislation without giving the public a proper notice of the legislation and proper opportunity to give input into it. And Chief Justice Norbo and the entire Constitutional Court set aside the legislation because Parliament didn't facilitate public participation. And it said that that duty on Parliament is justiciable. It means that judges can enforce it.
Yes.
Now, I think it's because people don't like that. They're uncomfortable with the idea that an outside party will say that there is a limit to your power or there's a way in which you've got to exercise your power. And my point, my club, with respect, is that under the rule of law, in a constitutional state, you cannot avoid that. If you have power, it's got to be subject to the law. And if you've got the law, you've got to have people who interpret that. And if that makes you uncomfortable, then you've got to find a way to live with it.
But I mean, that is fine, Judge. I mean, that I also agree with it, Justice Norbo, you know. That is correct.
But at the time it was very controversial. Now, 8 years later, we all accept it, that it's a justiciable obligation. I think you'll come to accept whatever decision the court may give in the speaker case as well, in 8 years' time.
Yeah, but my point, I think in the case, in that case, there was, I mean, Parliament did not comply with the law, and that is quite clear. But in this case, Judge, there is a gap in the law that requires the Speaker to break a deadlock other than that which is on policy. And I mean, that's only an issue to say we have a long-standing authorities in this regard. Obviously, one needs to appreciate the difficulties that judges get into when they sit on some of these issues, because they are not as easy as some of us may like them to be, or we seem to be putting across. But having said that, my concern is that we have a situation where we have eminent authorities, senior judges, who've been saying the same issue, to say, when there is a gap, when there's a gap in the law, let's not legislate as judges. You know? Let's take it back to the legislature to fill the gap. You know? But in this regard, you find that the Constitutional Court is somehow participating in the filling up of that gap. And I think it also intends to counter the legality. And my concern is not what the Constitutional Court is doing. Is if the Constitutional Court has to develop a process, ethos, a protocol towards that, which is different from the past, let us get a clear indication. Understand why. You know, let us know that, I mean, it is moved from this side to this side, and given the constitutional paradigm and the issues at hand, this issue cannot be left as it was. You know, it needs to be considered with a fresh perspective, and that's fine. But it cannot be that from an established perspective that when there is a gap in the law, then we don't take it to the legislature, and we don't get guided as lawyers and as practitioners, you know, to say how do we do it. Remember that we glean after you. You know, we pick up whatever, all the nuggets that you guys leave behind. So we need clarity in practice to say, then, as you advise a particular client, this is what needs to be done. And for me, I think that's the issue. We seek clarity, we seek a developmental pattern that we can all be able to understand. We don't need to agree with it, but you can all be able to understand. And particularly where it departs from an established position in some of the papers that yourselves and Judge Mayfield, many others that pronounce on. Because the pronunciation was simply that you find that the judiciary in some countries that is under the thumb of the executive or the elite or the legislature tend to behave in a manner where when there is a gap in the law, they fill it through some interpretation. They create their own context and then use an interpretation to fill the gap. And that was the point that was being made around the issue of judicial independence, to say in those type of issues, the court should not be pressurized to find an interpretation that suits whoever is in power, but the court should be able to desist from those type of practices. And I think that, I found that was quite persuasive.
But of course, we all agree that if our courts, and they have said that they do have in some instances power to read into a particular given situation where there's a gap. The Constitution allows them to read into words into a statute, for example, to cure if there's a constitutional defect. And the court has done that in many cases in South Africa. But in other cases, they have sent back to the legislature, such as in the case that dealt with the Civil Union Act, for example. They said, no, we'll send this back to the court would have simply read into that to deal with it differently. But I want to come back to, and I don't want to, these issues we can come back, but I want to come back to the issue of public confidence in the judiciary. Because I think that if I'm reminded of what the late Justice Muhammad said some years ago, that he said that the judiciary's ultimate power rests really in the esteem in which it is heard within the public and the soul of the nation. Those were his exact words. And I want to ask you, Justice Cameron, how can we ensure that the esteem of the judiciary, the public confidence, is never undermined?
Well, you can't ensure that it's never undermined, but what you can do is to get judges to try to earn public esteem. And it's interesting to me, there was a survey that was recently publicized about whether people had confidence in the courts. But what fascinated me is that the question in the survey didn't relate to the courts only, it related to the courts and the administration of justice. And the administration of justice included police and prosecutors. I'd be interested in a survey that taps people's faith in the courts, magistrates' courts, high courts, constitutional court, Supreme Court of Appeal. I don't think we've had a specific survey like that. But I agree with Chief Justice Mohammed that judges earn the esteem in which they hold. And they earn their esteem because their judgments are scrutinized, and because their conduct is scrutinized, and because their judgments must be rational. And you've got to, ultimately, I think it's the fascinating test to me in regard to the Constitutional Court and the Constitution is what do service delivery protesters do? They invoke the Constitution. They come to the Constitutional Court. What does the faction of the ANC in the Free State that said that there was a crooked provincial conference last year do? They invoke the Constitution, they come to the Constitutional Court. What does the DA do? What does government do? What do individuals do? Corporations do? They all invoke the Constitution. They all say, we want our rights enforced. So to me, that shows a wide measure of internalization, of legitimation, of acceptance, and of enforcement of constitutional rights, with a supposition that you're going to get at least a fair hearing in the courts, and maybe not a decision that you like. Mr. Langa has told us what decisions he doesn't like. Obviously, you're not going to please people all the time, but that the process of the decision-making will have integrity, and that even the decision itself, even if you don't like it, has got integrity. And I believe we've got that.
Thank you. Please, the audience, I'm going to ask the last question here to Mr. Langa, so please be prepared for your own participation in this discussion.
And be prepared to give Mr. Langa some claps.
But Mr. Langa, I mean, speaking about public confidence in the judiciary, I think I wanted to find out, do you think that judges' involvement in discussions like this, giving public speeches elsewhere, has in itself threatened the public confidence in the judiciary in relation to what they might say in those conversations like this.
Look, I agree with Justice Cameron that the judges, the judiciary, is quite intact, and they come out quite splendid in many respects. And I think probably amongst all institutions, we probably come at tops, and I agree with that. But it's a bit of a challenge. I think the question was that how could judges get more respect? That is a question.
Yeah, I mean, should judges watch what they say when they are out there in the public?
No.
Should we only hear from judges based on their judgments that they write, or should
Give
we
us some
hear?
examples of recent controversial statements that you want Mr. Langa. But don't be shy, Mr. Professor Mandel.
No, but no, I've
Give
heard.
us practical examples.
Let me give you one example that comes to mind. One example is a recent speech that was made by Chief Justice Mokwei.
Oh, you surprise us.
That's the only example that comes to mind.
I had the privilege of sitting in the committee that was establishing the Office of the Chief Justice. In that committee, one sat with the late Chief Justice Langa and also the late Chief Justice Checkerson. And they both said that the establishment of the Office of the Chief Justice is very much important to a judiciary, because they want the Office of the Chief Justice to be much its role and to be much more pronounced, not only of the Office of the Chief Justice, but the judiciary's role. It needs to be much more pronounced. That's what the two senators, the Chief Justice said. And Chief Justice Langa then told us a story as to why he believed that should be the case. He said that he went to Nigeria to meet the Chief Justice of Nigeria, but as they left his offices to go to the nearest restaurant which was in town, the Chief Justice of Nigeria was followed by the paparazzi. As we're sitting in the restaurant, the guys were taking pictures, whatever they choose on the menu and so forth. But then, because you are such a courteous and polite judge, he didn't ask him where he's supposed to, or what's happening with him. He then asked someone else to say, but tell me, why all this razzmatazz around the Chief Justice? Then he told the Chief Justice in Nigeria is very important. They make pronouncements in public, they comment on some of the important developments, and now they are very important. So that's why you see the journalists following, because these are very important people. Now, to come to answer your question, that is my premise. I think there is nothing wrong when judges, such as Justice Cameron in this public forum, come to talk to us, because I think that's very, very important to us. It provides insight. If anything, I think more judges should do that. And about what Judge McQueen said, and I think also, it's a pity that in South Africa, when an African and a white guy debate, racism issues are inferred, even where there's a disagreement. Even where there's a genuine disagreement, there's a lot of things, there's hostility that's getting imported. It's unfortunate, But I don't think there's anything wrong with what Judge McQueen said. I don't find anything untoward with the criticism that he got, That's part of the debate, that's part of democracy. And I think, if anything, Judge McQueen must talk more on some of these issues, because he was talking on the issue that affects us practitioners, that we are not getting work even from government itself, forget about the private sector, And I think he was making a very important point, that the independence of the judiciary will be undermined if Africans, practitioners, do not get work from government and the private sector. You must remember that when you are a legal practitioner in Johannesburg in 2030, you still face the same obstacles as if it was 1990. You know? The confidence on black professionals, it's an issue that has been disseminated over many years by even government itself, like various other stakeholders. And it's an issue that we need to be able to find a way as to how do we get the government and the private sector to support black practitioners. I know it's the same issue with black advocates, attorneys, and so forth. It's a problem. It's a problem because very soon there will be issue of transformation of the bench, transformation of the judiciary, and you have to draw from a pool of practitioners who have not campaigned at the high levels or in complex matters, and that creates a difficulty. And I think he made the point within the context that as Chief Justice, he made some observation that the judiciary deserves to have a much more richer pool than presently it has. And I think I was also talking to the pipeline, the development of pipeline of lawyers. We need a great deal of women judges from across color lines, and so forth and so forth. And I think you made a good point. I mean, again, but the criticism, I don't think it takes the decorum of the office away. I mean, I always say that as a lawyer, I always expect the next person not to agree with me, so it doesn't affect me if ever somebody doesn't agree with my perspective. It only enriches me to be able to see a perspective that I'm never.
Thank you very much. So I take it that once you are appointed Justice Cameron, you don't lose your constitutional right to freedom of expression. You still have the right to speak. Well, any justice, a judge, because of some of what the debate has been around is whether that you have the right to speak as a judge. At this juncture, I would like to open up to the audience so that we can also get you into this discussion. So please, if you could just put your hand and I will point at you, if you may. I see one hand here. Maybe I'll take 3 questions and then we'll give a chance and then we'll come back. So I see one hand here, and then I see a hand in the middle here, and then here, and then I'll come to the other 2 there. Please, go ahead.
My name is my question will go to Justice and Senior Attorney when you face the dismissal before the Constitutional Court, as also believing that I'm a member of the SADC, the citizen of the SADC, the DRC, making an application before the SADC tribunal, and the President, the Themba admit liability, as I requested the SADC tribunal to declare the Constitutional Court of South Africa judgment null and void and being groundless, not giving too much provision and weighing out the recent decisions. So, 3 years after, many attempts to the office of the current president, they will no answer. But some of the attorney approach, you may not be aware of that, but some of them even are not aware of the existence of the SADC tribunal. It was a confusion. But in my time, I also contacted the UN Chief of Human Rights, who say that you cannot deal with the matter unless the matter goes to the African Court of Human Rights, or if you can be given genuine reason why the African Court of Human Rights is not being exhausted. So I would like to hear from the panelists which are the possibility of accessing justice.
Okay. Yeah, right.
Hi, I'm Jackie Dubai from Seri. Justice Cameron, 2 quick questions. The one is, do you think that it would enhance the Constitutional Court's role and value in our society to allow direct access, genuine direct access more? And the second quick one is, in terms of the adjudicative style of the Constitutional Court, some people have argued that there is an element of avoidance where one can rely on a statute or a piece of legislation. The court will rely on that rather than developing the common law in light with the Constitution, etc. Would you agree with that, and if so, why? Why do you think the court has done that?
Yeah, last one, and we'll come back. Yes.
Yeah, thank you. My question is actually to Justice Cameron. I'm inclined to agree with Mr. Langa here with regard to the issue of the Democratic Alliance and not, the motion of no conflict. Now, in my understanding of the judgment by Judge Davis, he said that he recognized the fact that there existed a rule that Parliament could put through a motion of no confidence. The problem was that he did not want to delve into that arena whereby he had to give content to that rule. Now, by saying, the Constitutional Court by saying that go and come back and give us what you've decided, or we'll make a ruling with a lacuna, are you not essentially giving content to that rule that is being spoken about by Judge Davis? And is that essentially not meddling in the administration of the activities of Parliament itself?
Thank you. I'd like to say to the gentleman on the right, I'm sorry to hear about your case. I'm not able to give you advice here. The case sounds quite intricate. I think from the summary that you've given it to us now, I apologize that I can't give you an adequate response. And I'm sorry I'm not able to do that. To this gentleman, I would repeat that I didn't sit in that case. The court will give judgment, and it will speak for itself. And once it's given judgment, I'll not be averse to coming back here and to speaking about the judgment that my colleagues will give. And then Ms. Dugard asked two questions. Said they were short questions, but they're both very good questions. The one was the question of direct access, and it's a legitimate point of criticism to the Constitution. But the Constitution says that the Constitution Court shall allow direct access in accordance with its rules and where the interests of justice indicate. Now, over the last 2 decades, the court has said it's not often in the interests of justice for people to come directly to it. For this gentleman, for example, to come tomorrow morning, we have heard people almost overnight. We've allowed someone, Mr. Prini Motopeng from Soweto, came to us just before the elections in the municipal elections 2 years ago. He asked us to stop the elections because he wanted Soweto to be an autonomous district. We gave him direct access. We heard he wanted the state president's State of the Nation address to be cancelled. We refused him the relief, but we gave him direct access. But our general approach is that we want you to go to the High Court first, so that if there are factual disputes, the High Court can decide that. We can't sit as 11 people hearing witnesses and determining factual disputes. It's simply impractical. But the criticism that arises from that Professor Dugard gives is a legitimate criticism that we've been too chary of it. We've not given direct access. I think there are problems, Professor Dugard. I think there really would be problems.
I'm not a professor.
I can say other lovely things about you, but they're embarrassing. But the point is, I think there really would be difficulties. The Supreme Court of India takes direct petitions. It initiates petitions. In one case, the judges walked on the streets of Delhi and they encountered poor people who didn't have shelter, and they took the case. Now, there's something to be said for that, but I think that's very dangerous. We are more conservative, and your criticism, implied in your very quick question, is that we're being too conservative, and I think there's something in that. And the second question was about why we duck the development of the common law when there's a statutory way out. Well, Ms. Dugard is referring to a judgment that I gave that I think is a very good judgment.
It is a great one. It's a great one.
I'm teasing a bit, but we did do that there. But I think the court isn't scared of developing the common law when it has to develop. But thank you for both those difficult questions.
Okay. Yes. There's the hand here, there's one here, and then I'll come to this one here. Yes.
My question is for Justice Cameron. Sitting in the SCA in the case of Presley versus Trotsky.
Sorry, which one?
Presley versus Trotsky.
Yes, that's correct.
I think it was a minority judgment of Justice Cameron. You came down in favor of the Shifran principle. And in the course of the judgment, you said that good faith in the common law of contract is a mere value. It's not a substantive role of the common law of contract. You cannot refuse to enforce a contract by virtue of the fact that there was no good faith on one of the parties. So my question is essentially in light of Section 39 subsection 2 of the Constitution. Isn't it time that we develop the common law contract to make good faith a substantive value, to the extent that we can refuse to enforce a contract if one of the parties lack good faith? In the same way that we do when, in the case of misrepresentation, we can refuse to enforce a contract, or if a contract is against public policy or contra bono morals, we can refuse to enforce it. So isn't it time that now we make a good faith a substantive value of the common law contract?
Thank you for that. I'll come right there. Gentlemen, yes.
So, Mike, maybe I can give Justice Cameron a hand and then he can decide whether I give him a clap afterwards. So, the criticisms that have come out have come from two different sides here when we're talking about the separation of powers. On the one hand, there's this idea that there's sort of hands-free constitutionalism and the court goes too far. On the other hand, there are many cases in which the court is criticized for head-in-the-sand constitutionalism, where they don't do anything at all. But what strikes me is that part of the reason for that, and there's a recent judgment, I think it's in the NSPCA case, a judgment of Justice Zondo, which articulates 5 bullet points of what we know about the separation of powers in South Africa. Part of the problem is that we don't know very much about it. The court hasn't told us much about it. They have told us very long ago that there's going to be a South African doctrine, and that we mustn't just look at other countries, and that we must try and mold our own way. But part of the problem that I think that the court has with the criticisms that come is because the court tells us so little about what the court's powers are that we are left to guess, and that means that anyone from anywhere on the spectrum can just leverage the same criticism over and over and over, which I think is a little bit tiring for the court. So my question then would be, and you can decide whether it's a clap or not, why is it that we've seen the court promise this doctrine and then not expand upon it and leave us to guess from case to case what role the separation of powers is going to play in a certain decision, whether the court is going to defer, whether it's not going to defer?
Okay. Thank you for that question. Yeah.
Again for Justice Cameron.
I thought there'd be claps for Mr. Langa.
Okay, all right. I will address it at to both of you. All right. So would the two of you say that the simmering tensions, ongoing tensions at Marikana as we speak, is an indication of, a failure in social justice? The panacea for all social ills, but I'm just wondering, in terms of social justice, why do you think that we are failing? And then my second question is a more academic question in a sense. Tinus Roux, his writing is very much about the court being torn between these two poles, being building legitimacy, which that study by the HSRC suggests they're not doing that well, and the other pole being a more aggressive check on government than one would perhaps find in a state with a not as dominant majority party. Where do you position yourself between those two poles? Because this is about judicial philosophy. So I
ask the Chairman's protection against non-academic questions.
Okay.
Well, thank you for that. Justice Cameron, the other speaker as a way of developing the separation of powers in South Africa.
You see, it's a good question. The Chairman has very, very helpfully illuminated it, because we don't, in America, the Supreme Court says some questions are just political, we're not going to go there at all. In Israel, the Supreme Court of Israel, when confronted with evidence that the apartheid wall on the West Bank was intruding on Palestinian territory, which was under international law, it was not permitted to do, said, we're not going to go there. We'll determine the details of where the wall might go, but we're not going to declare the wall illegal on the basis of international doctrine. We don't have it in those terms, and Mr. Fisher's right to this extent. I just don't understand how a court can give a future projection of what it's going to say when the court's job is not to give future predictions and general doctrinal statements, but to decide disputes before it. That's how courts work. So I don't think we can do what you want. And then I want to thank that gentleman for his question. Brisley versus Brodsky, most of the judgment in Brisley versus Brodsky was later accepted by the Constitutional Court in Napier and Barkhuizen, but it emphasized the point that good faith could be a determinant of contractual validity. And then in a judgment that we gave, and one of the authors of the judgment is sitting behind you, Justice Furneman, the Everfresh judgment, both the majority and the minority said that the time has come to bring good faith in. So if you read Everfresh, I think you'll be very pleased with both the majority and the minority. Justice Furneman would have gone further than Justice Mosadeke's judgment, to which I subscribe. But both the majority and the minority said the time has come to make good faith more of an impact in contract doctrine. So thank you very much for your question. And then Professor Swart.
Now it seems so uncool to be a professor now.
I can also say nice things about you. But the fact is, sorry, and I'd like to hear Mr. Langa's views on that question as well. The fact is, as you say, and as Jackie Dugard suggested, that some people say the courts aren't doing enough. And the fact is that there is so much wrong. We're sitting here in a warm room, we've all got cell phones, we've all got meals to go to later, we've all got room, shelter, but many people in our country aren't like that. The question is, what can judges do about a palpable social crisis? A crisis that many people think government isn't managing efficiently enough. Some people give government more credit or less credit. I'm conservative about what the courts can do. I think the courts have done a lot. They've done a lot through their rulings on housing, their rulings on education, their rulings on basic social rights, their rulings on separation of powers. But some people want the courts to do more. And I want to go back to the Merafong example that Mr. Langa gave. Merafong was a demarcation case where the people just 70 kilometers to the west here in Carltonville were very angry about being taken out of Gauteng and put into Northwest. And it was eventually settled politically. But there were two other cases where the politicians promised to settle them politically. They concerned Matatiela and it concerned the Mutsi area, which is just north of Groblersdal. And the Mutsi residents came to us and they said, we are unhappy with the demarcation and we are unhappy with the fact that the politicians haven't helped us in the way that they promised to help us. And we scrutinized their case. And Deputy Chief Justice Moseneke wrote the judgment. And he went out of his way to see if there was a way the court could help the Mutsi people. We gave judgment saying we could not help them. We left the court and my law clerks came and told me that the people of Mutsi, 200 or 300 of them who had come, were very angry with us. And my answer was that they shouldn't be angry with us, they should be angry with the politicians who let them down. So we've got to leave something up to democracy. And I don't think that we're leaving enough up to democracy. I think we're doing a lot. But that's a judge's perspective, and I still want to hear Mr. Langa.
Look, I think Jackie's question profound. That, what the Constitutional Court, shouldn't the Constitutional Court do more than it is doing? And I think we all concede that our courts are doing have done much. The Constitutional Court in particular have made significant strides. But I think in the light of Professor Swan's question, on the issue of Marikana, I would think that there should be some measures that judges could do. Particularly because we appear to be in dire need of leadership in certain areas, where we do appear to need assistance to be provided to political leaders.
You think we should give more?
Look, I mean, not suggest that they're not doing much, but I think, the question, it resonates. That, if you wouldn't do more than you're doing, but I think it will suffice of an inquiry to establish what other measure can we be able to do. Because the difficulties that the country is faced with now are quite too heavy. Just as Seneca made the point that the Constitutional Court and the Judiciary, they've contributed more than probably government in providing access to constitutional protection and constitutional rights. And until he made the point right away that indeed it was that much, I think it would be worthwhile to consider it.
Come back here. I see the hand in the back there, and one in the middle here. then, yeah, and then one on the left. So let's start from there, and then we'll move to this side. Go ahead.
Hi, it's Themba. I work at Sonke Joint Justice, and I wanted to ask Mr. Langa how he hopes that the court will be able to transform our democracy, because we do have a transformative constitution, in a way that brings about social justice without in some way, enforcing checks and balances. I'd also like to know what role Justice Cameron sees civil society playing in supporting the judiciary in effecting social change.
Let's go to you. Yes,
okay, I would like to somewhat differ with what Mr. Langa said, in that court should that some political cases should, political cases must be ousted from the jurisdiction of the court. And I say this based on the Patricia DeLille case. It was a minority member of is now part of the DA, who was suspended by the Speaker of the Parliament for throwing a defamatory statement. She went to the court and she did get remorse there. And the role of the courts is to protect minorities, and those minorities are also in Parliament. And we always hear the ANC, when matters go out of the court, they're very quick to say that this is the matter that should have been settled in Parliament. And it's also understandable why they say that, because they are the majority in Parliament, and whatever they say will go on there. And so I wouldn't want a situation where the minority in the Parliament is not given a chance to go out and seek a recourse elsewhere.
Yes. Yes, right.
So my question is to Mr. Langa. So recently, I think it's the 17th Constitutional Amendment Bill, or I think it's an act now, has enlarged the jurisdiction of the Constitutional Court to hear non-constitutional matters. I'd just like to ask you as a practitioner, what you think the consequences of that amendment are going to be, and whether you think it's a desirable amendment.
Okay. I'll give the chance to our panelists. Anyone of you can go.
Okay. Then we go first.
I think both questions were to you.
Look, I mean, on the transformation of the judiciary, for me it's it has been a bit regrettable that we just focus mainly on the issue of color, not on the issue of resources, and in order to be able to transform. Because what we are faced with now, we're faced with a situation where, if you look at them amongst magistrates, you've got the majority there are black, and someone could say that indeed the judiciary has transformed. And even when you look at the amount of judges, the numbers are improving to be increasingly black. And is that a desirable situation when you say that we want to transform the judiciary? It may well be, I'm not discounting that aspect, but I think we need much more to be done. As I said earlier, that the difficulty that we have in South Africa, we do not tend to focus on the substance part of transformation. We are looking too much, focus on color. I can take another example, look at the case of land distribution. The law focuses on the purchase of land and to be given to an African community. It doesn't matter whether the farmer who used to own the land owned the Mercedes-Benz, owned tractors, owned everything. We're only talking about the land. And that's not what makes the land to... and if you only get the land, you don't get the tractors, you don't get all other implements. You won't be able to make the place to be productive like the white farmer used to do. So we tend to focus too much on color, in my view, at this stage of democracy. And I think we should be able to put much more substance, like in the case of land distribution. Focus on distribution, but focus as well on the utensils, on the tools that you need to make that same land to be as productive as it was under a white farmer. Similarly, when it comes to transformation, we should not exclusively limit it to the issue of race and gender. Those two issues remain important, but we should also include other issues that Justice Mkwena said. The issues of getting briefs to black advocates, getting work to black attorneys, And by so doing, you're enriching the transformation of the judiciary. It does not become a color issue. So that, for me, that is my response. On the issue of that I said that the court should not get involved in political cases, probably I didn't come across well, but that's not what I said. I said it would not be fair to say that the court should not be involved in politically sensitive matters. The courts have jurisdiction over various, if not all, other matters that may arise under the skies of South Africa. However, in respect of issues of parliament, this is not an issue that arises since 1994. It has been there ever since. And there is courtesy and wisdom in respecting the boundaries of separation of powers. Where, in my view, the Constitutional Court is seen to be interfering into certain spaces, such as maybe trying to dictate to Parliament as to how it should administer its own affairs, how it should administer to break deadlock. I think for me that's interference, and I may be wrong, but it's not necessarily that represents all political cases. That's not the case. It is only that situation that I think the Constitutional Court should observe the long-established practice by judges of self-restraint. So they must not be seen to interfere into those type of issues, because then they're going to be accused. I mean, you see the issue in that case, like the motion of the Democratic Alliance, where it creates difficulties is not for judges, but it's for the Republic. We do not want a situation where our judges are said that they've got into court and able to tilt the scales in favor of the other party. We don't want that. You know, our judges should be able to focus, they put ample work on the issues that where they have to conduct their own review and even where they have to get into uncharted waters into. But there is wisdom to say they should not be able to get in some other matters. I mean, I know that former Justice Kate Olgen as well had a similar concern, even around the similar case. That, I mean, that the judges should be careful not to be seen to be legislating in some respect. So my view is not different from what other eminent judges have said. On the issue of majority and minority parties in Parliament, you know, we should not try to legalize everything in South Africa. You know, I don't like that approach personally. In America, there's the filibuster mechanism that politicians use inside Congress. It's a mechanism that they use to block debates, to avoid issues and so forth, you know. So in South Africa, when you get something like that, it goes to court, you know. And we should be able to allow our own political scenery to be as developed and to be as entertaining and leave it to the powers that be inside Parliament, as long as no one commits a crime. To the extent to which the lacuna that is there, that has been identified, maybe filled, let it be. But we should not try to legalize and try to make everything to be subject to judges at the courts. I think that may be cumbersome. On the issue of the constitutional amendment, I think that's a very good thing. And I think it's a very good development. In that, I mean, there are many instances in my view which present themselves and which they may require the eminent justices of the Constitutional Court, other than having to go through all the other courts before you get to the Constitutional Court. And I think, I mean, which is a court that was made up of access to the court. And I think that is going to be very helpful. It will make some of us to bring some of the matters that we've been itching to bring forth. So that it's quite a good one.
Yeah, thank you. Just for me, you want to make
I just want to quote one thing. The gentleman here who spoke about minority participants in the political process, and it goes back to the first debate that Ms. Langa and I had an hour and 20 minutes ago. We had a very interesting case last year where Mr. Mario Ambrosini, who is from a minority party, complained that the Constitution said that a private member, any member of Parliament may table a bill. And the rules of the Assembly said, yes, you may table a bill, but you've got to go through a committee, and the committee was dominated by the governing party. So private members' bills almost never made it through that committee, and he said this is wrong, because the Constitution says that I can bring a bill. And he came to us, and we gave a unanimous ruling, which said that a private member is entitled to bring a private member's motion to the floor of Parliament. It can die thereafter, but he's entitled to bring it to the floor of Parliament. And the judgment was given by Chief Justice Mogoeng. And the reason for his judgment came in a sentence that he says, the Constitution is there for those of us who might not otherwise have wanted to listen to the views of minorities in our society. And that's Chief Justice Mogoeng's philosophy, and is also the philosophy of the Constitution. And he was accurately voicing it there. So I think it goes to support your point, and it does also indicate that Mr. Langa's disquiet at the start of the debate about when the Constitutional Court, we did intervene in Parliament's rules. We declared Parliament's rules unconstitutional, but we did so because we thought the Constitution obliged us to do so. And may I say, if this is my last word tonight, Professor Mhango, that I really want to say that I know that there are misgivings. I know that there are hesitations. I know that there's sometimes even disquiet about the amount of power that judges sometimes have to exercise. But I can tell you that we do so with great anxiety, and often, as some of the other questions have indicated, with too much anxiety about not going too far. But I'm very glad that we have common ground, that we do so with integrity, because without that common ground, we can't even go further. So thank you.
Mr. Langa, I wanted to give you an opportunity to sort of say some of your own closing statements that maybe you may have wanted to say, but the chance didn't come about.
Now, look, I mean, I really appreciate the opportunity, and I think, it is quite important that to also to get the insight from the Constitutional Court, Justice, about to what extent do they get thrilled or do they get anxious when they make some of these decisions. Most of the times, it doesn't come across in that fashion, but I think it's quite an insight. And I think, again, such a debate as well, as I said, just to say the type of measures I said earlier on, I would hope that the judges should be much more conscious in public, because, we tend not to understand what is it that really affects or makes them to be anxious, or how do they approach some of these intricate issues until you find an opportunity to be able to go and act at the high court or to be able to have such an opportunity. So I think it's great.
Thank you for that. And I think I wanted to, if you can indulge me, I wanted to end with something that you mentioned about transformation. We tend to focus on the transformation of the judiciary, on the race and gender. And I think you're right. Those are important. But there's something that we often don't discuss about, which is what the notion of called transformative adjudication, which is the idea that Justice Langa said it very, very well. And I want to end with this by saying what he said. He said that transformative adjudication demands that all decisions be capable of being substantively defended in terms of the rights and values that it enshrines, the Constitution that is. He went on to say that it is no longer sufficient for judges to rely on the say-so of Parliament or the technical readings of the legislation as providing justifications for their decisions. Under a transformative constitution, judges bear the ultimate responsibility to justify their decisions, not only by reference to authority, but by reference to the ideas and the values that the Constitution espouses. Now, in my view, judges are doing that through the judgments that they pronounce, but they need to do more. And I think part of Justice Cameron being here is part, I think, in my view, part of that transformative adjudication. Sitting with us here, giving us reasons why certain decisions are made, and how the Constitution demands that those decisions should be decided the way they are. I think that, to me,
is part of the constitutionalism you spoke about, that this is the path that we must follow. So I thank you for being here, and I thank you, Mr. Langa, for being here, and I thank all of you for being here. I hope that we can have this conversation again. Thank you.